do we have some comments from Douwe, from Drassen, from Ian or other people?
Kick off, if I may. Can you all hear me? Is the system working again? You might as well keep our fingers crossed. I don't have that many very specific comments because it is not possible to go into the detail of every country, and also you would need a day on each country before you understood it. But what jumped to my mind was, of course, that many of the systems, especially, of course, the South European Balkan countries, have already made an awful lot of changes, in particular in changes from the task of the prosecutor to give more tasks to the judges. And I think that is very much to be encouraged, to have judicial supervision over as many of these measures as possible. But I also noticed that an awful lot of you still fall back on old, very generic provisions. And that doesn't sound to me like it's very good. It is good, I think, to have a special section in the Criminal Procedure Code on special measures. It's usually called special investigative measures or whatever. And to deal with these matters as much as possible in a harmonized way in consultation with the Council of Europe, so that there is some more communality about what level of authorization you need where. I was a bit puzzled by too many instances where there is still very low level authorization for what can be quite intrusive actions. And I would hope that in consultation with the Council of Europe that can all be raised up, so that prosecutors and investigators and policemen become aware that these are very human rights sensitive measures, and that therefore they have to be exercised subject to very strong and solid safeguards. I was just talking to Alexander there, saying, can guidance be given on the convention? And it looks like in the future there might be more formal guidance, probably not binding guidance, but more formal guidance. And I think these are all areas on which that would be very useful. And one, just to go back to my hobby horse, what I also put in my paper, I think it is I would make a distinction that is not in the convention between really basic traffic data, when did somebody telephone somebody else, and location data. I really think location data are extremely intrusive, and the non-recognition of that fact by both the EU legislation, data protection legislation, and in the Cybercrime Convention, I think is problematic from a human rights point of view. But it could be resolved by just recognition in the practice of states that location data need more protection than other kinds of traffic data. That might be a way of doing it without having to go and think about amending the convention, which would be impractical. Those are basically my own observations from the discussions. Another thing, from what you're saying, it was all very much on the procedure on paper. I think it is very important to get practical information on how much use is made of these powers in practice. And those statistics would have to be meaningful. It is very, very difficult, Ian will be able to say something on that, to really see through the statistics, even in the more developed countries that we've looked at, to see what really happens in practice. And I think in a good democracy and with the rule of law, the citizens and parliament should be able to have a really good understanding of how often certain powers are used and for what kind of crimes they are used and how effective they are. The Max Planck Institute in Freiburg did a study for the European Commission on the effectiveness of the Data Retention Directive. And the amazing conclusion was that there was no, in spite of them having asked all the EU member states and all the police forces in the member states for solid evidence of the usefulness of data retention, that no such evidence was provided. No serious evidence of retention as opposed to preservation was forthcoming. And that was from the most authoritative study that I could have thought of. So I think it really is important to look at the practice of these things and what works, what doesn't work. If something isn't necessary, don't use it. Ian, can you say something maybe about those statistics?
And also on the data retention evidence that Douwe just mentioned, the Commission's own working paper, which was leaked, I mean it was meant to be confidential, but it's on the internet, concludes precisely as Douwe just said, there is not the evidence to justify this extremely intrusive measure. Several constitutional courts of the member states have ruled that parts or all of the retention directive are unconstitutional nationally. I think Bulgaria's, coming back to the point on Croatia, Bulgaria's court found that giving direct access in the way that Croatia was discussing was unconstitutional in Bulgaria. Romania found that the whole principle of data retention voided the principle of privacy and data protection and was unconstitutional. Germany's, I've got the quote about what specifically they were saying, but Germany's constitutional court said there were great questions, and if retention went any further than the directive currently, that the minimum levels that the directive proposes, then Germany's constitutional court would have trouble. So I think there's a great deal more transparency needed about what's happening and how the powers are being used to justify that level of intrusion. We are having a debate in the UK now where the UK government has proposed greatly extending the data that they could require internet service providers to keep about people's communications. So going beyond what's sort of broadly understood as traffic data about things like email senders and recipients, to start looking at social media, online games, virtual environments, anything where people could be communicating, which would need very intrusive monitoring within the ISP's own networks and the gathering of a lot of data. It's much harder to draw a firm line there between content and communications or traffic data than is done in most existing laws, and there's been a lot of criticism of the draft bill in the UK Parliament, and whether it passes in anything like the current form, I think will be very interesting to see.
Okay, there is, if you want any conference on cybercrime to get into a direction which will not lead anything, is if you raise data retention. It's a difficult one to come really to a conclusion at this point. I think in the case of Romania, they now have a law in force again. They have a new law in force, which they believe is constitutional and so on. I don't know which report, because there are several reports being prepared apparently to check on the retention directive, including one comparing data retention with preservation. Is that one? But it was not Max Planck Institute. That was done by somebody else.
This was done by the Russian lady we met in Stockholm at the Max Planck Institute.
Okay. Okay. As I said, the Cybercrime Convention Committee, and a number of you are members in that, is currently assessing the preservation provisions. And in the provisional report, it was discussed in June. We came more or less to the conclusion that for each preservation request, there are at least 1,000 or more requests for access to retained data, which means that there's maybe an overuse of access to retained data and certainly an underuse of the preservation provisions. The point you made about using specific provisions for certain measures is also will also be underlined, has been underlined already by the TCY, the Cybercrime Convention Committee, that too many parties make use of other powers than having a specific preservation power in place.
Just a specific point on that, Alex, that this is one of the problems the Commission had in trying to assess the proportionality of retention, was that the very limited data that there is out there tends not to make a distinction between data that would have been available anyway because it was being held by ISPs for business purposes, as opposed to data that was being held specifically as a result of data retention rules and laws. And it is dismaying, I must say, if you believe in the rule of law and of human rights and a European Union that supposedly is founded on those principles, to see a directive which has been so heavily criticised and for which the Commission themselves cannot justify that level of invasion. It then comes down to pure politics, that it's just a small number of the large member states that are determined to retain the directive that has stopped the Commission from revising it.
So we are now getting into waters where we will not come to a conclusion, certainly not before the session closes. We will see what happens. The fact is, under the Budapest Convention, you don't have data retention, and I reserve my position on whether I think, my personal position, whether it's useful or not to have data retention. Other observations on the systems in place in different countries?
Again, I would like one question that I didn't hear addressed an awful lot was this technical means of accessing computers by the law enforcement authorities. In other words, not search and seizure, but actually using Trojan horses or whatever. What in Germany they call online search, and the similar powers I mentioned this morning that they were introduced in the Netherlands. One particular problem with that is, which I discussed with Ian last night, if the law enforcement authorities fiddle on with people's computers, that contaminates the evidence. If later on you seize a computer from a suspect and it transpires, first of all, that there are things on that computer that incriminates that person, but secondly, that the police has had access over a certain amount of time to his computer, how can you prove that it wasn't the police that actually put that evidence against him on the computer in the first place? So this is a thing that may well bite back if it is too widely used. And of course, on top of that, it is an extremely intrusive means of investigation. And if you were to do it internationally, I think there really would be serious problems with what the Dutch are proposing, with the Dutch trying to access computers in America or the Americans accessing computers in Germany. That would really be highly problematic.
Okay, any comments on that? Turkey? We need to have the microphone over there.
Hi, I'm not against human rights, but I am responsible for investigating crimes. I just want to learn, or first maybe we should make something clear about data retention and what sort of data we're talking about. The first thing, for example, ISB access log records are data that you mentioned also, right? So subscription information. So this is nowadays. If I'm wrong, please correct me, other investigators here. This data, this subscription data is basing and underpinning all investigations nowadays. So if you don't keep those records, the IP addresses and the date and timestamps to the internet that they accessed, you can do nothing. You can't even not start.
I think, just to underline, I think the civil liberties groups do not argue against data preservation. We are against data retention because it is a measure of surveillance aimed at people who are not under any suspicion. Data preservation, we have no problem with, provided it is surrounded by adequate safeguards. But data retention, there is a fundamental problem with. That is the real big problem. On what data exactly are being accessed, I think Ian will know more than me, but one particular problem there is do you only look at the beginning of the URL, the example I gave, Google, and then a backslash, or do you go and include the search terms as well, and then again you get very intrusive in what you're looking at. You have to look at these kind of technical details, I think. Do you want to add anything?
And certainly there are, this is what Darren and I already said, different levels of intrusiveness associated with different types of traffic and communications data. So the basic subscriber data that you just mentioned, I think, is less controversial, the retention of that kind of data. But when you start talking about people's real-time location, for example, when you start talking about websites that people are accessing, which the UK included in its original data retention laws, then I think there is much greater potential for intrusion. And at the very minimum, I think you need correspondingly greater oversights in the use of that data, which in many countries just don't exist, that basically, including the UK, law enforcement agencies basically self-authorize access to that data, rather than, as with interception, there being usually much higher standards of judicial oversight, for example, in many countries, and authorization of specific intercepts.
simple preservation of data doesn't mean that the data will be disclosed. After some time, if you preserve that data for a month, two, maybe there will be no doubt that that person has committed a crime. So the simple preservation doesn't mean nothing till the production order is issued to disclose the data.
That's the argument the UK government made, for example, in Essen Marper.
Not retention.
No. This is. I know. I understand what you're saying. Let me finish. The UK government likes to make that argument that storing data has no privacy implications. It's only the use of the data that is invasive of privacy, and that is not what the European Court said in the Essen Marper decision.
Yes,
unless I'm misunderstanding what you're saying.
I'm explicit. It's not retention of data of any person. We have suspects. There is a possibility that his traffic or any other data will be erased.
Yes.
We ask to issue an order to preserve the data till we collect more evidence that it's really him, you know.
No, I understand all of that, but I see what you're specifically saying. Specifically, if you have procedures in place where it's a targeted measure, that's fine. What I'm saying is the broader argument which the UK government repeatedly makes, that just retaining data has no privacy implications. It's only when you come to use the data that you have to consider the privacy implications, is one that the European Court has rejected. I understand now the distinction you're making between targeted preservation following a specific decision that you've made that somebody is worth investigating.
We are spending our time discussing retention. So there's an overall, maybe in the beginning, a philosophical issue, but it has indeed consequences, practical consequences of the right of people, where you say, on the one hand, there is a specific suspicion of a specific offense, and therefore specific data is to be preserved, to give time to obtain judicial orders, to obtain a disclosure of data, or in an international case, to obtain the MLA request from another country. That's one scenario. That's a scenario covered under the Budapest Convention. The other scenario is anybody eventually could become a criminal, and therefore let's keep whatever we have in case we need it, in case people really become a criminal. Now, and there, the compromise was, well, it's not really with the government, it's with ISPs who retain it, and then if there is another step, with a purpose limitation in the directive for serious crime, access can be obtained. Now, one problem is that many governments did not keep the purpose limitation of serious crime, and there are no specific procedures on how to obtain the data or no safeguards on how to obtain access to the data and so on. You now have the situation that in some countries you have hundreds of thousands of requests for access to retained data. In other countries, it's very difficult to obtain access to retained data. It's easier to obtain access to content data than to traffic data, because traffic data is governed under the data retention law, where you have a high benchmark, while you can still get access to content data under other legal provisions. You have it in 2-3 parties to the Budapest Convention, which is also an absurd situation. When you come to the earlier point you made, and sorry, just to underline, there's indeed this issue that even the fact of data being collected somewhere affects the rights of people. If I know that my data is kept somewhere, I act differently, whether or not I'm a criminal here or not. But I act differently, it affects myself. So therefore, there is an issue here. The point you made about governments using the federal Trojan, as it was called in Germany, Bundestrojaner, government inserting malware in order to obtain access at source before data is encrypted and so on. There can also be the argument that there you search a specific computer, a specific machine, which may be less intrusive than if you have to intercept each and everything coming from a certain IP address. Again, you know, it's an argument. Or if you talk about international requests, where one law enforcement agency of one of the larger EU member states says it's less intrusive if I ask Google directly to intercept a communication between two Google IP addresses in my own country, not the US, but in my own country. I cannot get it. I would have to go through MLA, interception of a communication. But what I have to do is I have to go in my own country to the access provider and intercept everything. Much more intrusive than if you intercept the communication between two Google.my country users. So for everything is true and also it's contrary, right?
No, but I think you can always find solutions that match the intrusiveness to the level of authority and the amount of depth of intrusion to the seriousness of the crime. And the fact that you have these strange distinctions that have been brought about by legislative developments was a good reason to tidy all that stuff up in national laws. But I would, first of all, I don't think anybody can doubt that compulsory retention on millions of people is a very serious measure in a democratic society. That's a good start. And your quote of the German Constitutional Court, you know, if I think that the state can know whatever I'm doing and where I am and who I'm with, then I will act differently, and that has a chilling effect on democracy. That's a good quote. So at the very least, you would expect very strong evidence that compulsory data retention without suspicion is much more effective in practice for law enforcement agencies like you than targeted data preservation or even targeted entering of a computer. And for some strange reason, that evidence doesn't materialize, in spite of quite a lot of people having asked for it, looked for it, commissioned studies. The police authorities, and it's you around the table here, do not provide solid evidence that would justify the kind of intrusive measures that at a political level people are asking for. I find that serious.
Okay, still on this data retention stuff. But I would like to make one point, because I realized it myself as secretary of the Cybercrime Convention Committee when trying to compile all this information on the preservation question and so on. The issue is so political that you don't get the right information anymore because the right people may not be even asked, or they may not dare to speak out. In some countries where you have a fight between, let's assume, Ministry of Justice and Ministry of Interior of different positions, which may happen in some countries. One ministry tells you the complete different from what the other ministry tells you, or one ministry doesn't let the other ministry speak. So I don't think there is real access to the right type of data, and therefore it's very, very difficult to draw conclusions from that. That's my experience.
But that is not the onus is on the people wanting to justify this extraordinarily invasive provision. It's not a sort of, you know, Home Office says one thing, Ministry of Justice says another, so we can't decide. We need, as citizens and legislators especially, and courts need hard evidence about this, and until it's there, then I would say these provisions are not justified.
Hello. Okay, just one short comment again on data retention, and then perhaps you can move it someplace else. I'm very sympathetic with that famous judgment of German Constitutional Court in the census case, when they declared that the retention of any data will hurt individuals and consequently the society, because the individuals will adjust their behavior because they expect their data to be collected and they want to adjust to certain expectations. However, it appears to me that that conclusion today is least slightly unvalidated by the fact that those same citizens today routinely give large amounts of their own data to various private institutions, let's say Facebook, Twitter, whatever you name it, and they are not at least concerned about the possible implications of their actions. So in my mind, it is much better and much like better attempt to attack data retention schemes on the basis of their ineffectiveness. I didn't know about the study you quoted, and it strikes me as like very, very important. Thanks.
Sorry, it's very important I respond to that point, because you so often hear that Facebook shows that young people don't care about privacy. And when you actually look at social science evidence about what young people do think about privacy and how they decide what information to put on Facebook and who to share it with, it is not true at all that young people don't care about privacy. They don't even realize that it's being used for some of the purposes that we're talking about today, like law enforcement and advertising. They're just naive about how it's used.
Okay, in my opinion, we need better rules, clearer rules, more harmonized rules, and better safeguards. Whatever they look like, and they have to be justified and so on, and proportional, and all these things. So we can agree on that. Okay, very good. Should we move to other comments on this debate? If not, should we move to some of the points that we still wanted to discuss this afternoon? Namely on the issue of law enforcement access to data held by private sector entities, which is related in a way to this item, but also the issue of national security versus criminal justice. How does that come in particular if sometimes the same agency has functions in both areas? How does that come in? Would you like to kick off? Maybe with the G&I?
And yes, well, if maybe Ian, do you want to?
I think we've said a bit already.
I will start on a few of the things, and Ian, you will come in if there are other points. Let me take this off. I think in the new e-world that we all live in, the police too, and law enforcement agencies and national security agencies are operating in a new environment that really is quite different from the one when criminal laws and criminal procedure laws were drafted 100 years ago. And there are a number of typical features of that new environment. And one is the pervasiveness of the generation of personal information in all kinds of settings, both your machines, the fact that everything you do is being recorded, where you are, what you do, who you're in touch with, where you go, what you pay, which train you get on, which underground you get on. Pretty much everything is recorded in a personalized form, and it is increasingly bandaged around all over the place, and there is no incentive to delete the data anymore because data storage is so cheap. Secondly, the globalization of data. Data are in the cloud, they're all over the place. There was a big debate, of course, about PNR data a few years ago, and a big battle between the Europeans and the Americans over PNR data, passenger name register data, data. If you look at, what's his first name? Hasbrook. Alex Hasbrook, another Alex, who studied this extremely closely. He's got a fantastic series of slides. There's a fly who's trying to stop me from talking. That actually shows that the whole debate was beside the point, because these PNR data are held all over the world anyway. So the United States can have access to all your PNR data, whether you fly from Frankfurt to Munich. It is on a server in Melbourne, and on one in Canada, and on one in the United States. So the data are everywhere. Now that opens both fantastic opportunities and dangers. One particular problem that Ian and I have talked a lot about is profiling, and increasingly police as well as intelligence agencies are using profiles in order to try and find people who are likely to be criminals. And there are all kinds of problems with profiling. I won't go into that, but they are really, really significant. And they undermine the relationship between the individual and the state. The final important aspect of this is that an enormous amount of what happens on the internet is in the hands of private entities, ISPs and mobile network operators, rather than the traditional state bodies. Telecommunication organizations used to be, PTTs everywhere in the world used to be state bodies, and they are now private entities everywhere. They have an enormous amount of power over what people can do in the online environment. And partly the state would like to draw on that power. They would like to have some of their data. They would like to tell them to do what sort of things, to block certain sites or not block certain sites. At the same time, the state is often very happy to do this at one remove, to leave things to be regulated by industry, supposedly on a voluntary basis, sometimes with a nudge from the state authorities, who might encourage the blocking of certain sites, for instance, and certain actions against alleged copyright violators, but at the same time don't make the state responsible. That puts the individual in a very vulnerable position, because it is very difficult to maintain your rights in an environment where the people who actually impacts on your rights are not public authorities, and you may not have a remedy, and they may not be in your country anyway. So we are in a really different world for law enforcement, also for individuals who want to do things like political activism online, the right to organize, the right of association. People associate on social websites. It's an Article 11, not just Article 10 issue. People make expressions on all kind of places that may pop up in all kind of other places. The distinction between journalists and citizens, ordinary people, is disappearing because there are lots of people blogging to a smaller or a larger audience. And then the final significant problem with this, and I tried to highlight that in that paper that I sent around, is that because the internet is so international, it's very difficult to apply national laws. All the crimes that are listed in the Cybercrime Convention are given quite considerable, leave quite a lot of scope to states to implement in different ways. There can be differences about the seriousness of the crime, the level of intent, and I looked at the reservations and declarations on the Council of Europe website, and you can see that lots of countries operate these crimes in a different way. Applies especially to the additional protocol, and which touches directly on free speech. I realize that Article 20 of the International Covenant on Civil and Political Rights requires limitations on hate speech. But what those limitations are is addressed in very, very different ways in different countries. In the United States, First Amendment protection, you're allowed to say all kinds of things that here in Europe we all feel should be criminalized. And then you enter up with a world in which people say something in one country that other people can read in another country, and that the authorities in that other country may want to criminalize. We've had that one case, I keep on missing the names, the French, anyway, the French chap who lived in the UK, and he owned a porn website in California. And he was prosecuted in the UK because the website could be accessed from the UK, and he was convicted for obscenity. And he took his case to Strasbourg, and he argued, but not very well, I think, that he shouldn't have been prosecuted in the UK, because what he did was lawful under Californian laws. And Strasbourg unfortunately didn't look at it. I think we will need in the near future some rules on appropriate forum and appropriate jurisdiction. When can a state claim jurisdiction over actions by non-nationals that take place outside its jurisdiction, when there are impacts of those actions in its own jurisdiction? If all states claim jurisdiction at the same time, you are in madness land, where everybody who says anything that contravenes Iranian law or US law or Russian law can be prosecuted anywhere. So we will need some rules on how to limit that, and I do not quite know what those rules can be. That ties in with extradition, and there have been a number of very big cases recently in the UK, in particular the McKinnon case. I don't know whether you've heard about it. He was a hacker in the UK who hacked the Pentagon computer something like 10 years ago. It must have been. He thought he says he was looking for a UFO information. It doesn't really matter. He got into these computers. The Americans regard him as having seriously breached their security. Under UK law, he would have had a slap over on the wrist. It was a minor misdemeanor of entering somebody's computer without. He didn't damage anything. He left some stupid messages. In the end, the UK decided not to extradite him on medical grounds, but they were otherwise inclined to do so. Now, should he not, his parents, his mother's strong campaign was that he should have been prosecuted in the UK rather than India and then handed over to the United States. And there have been quite a lot of these cases. There are other problems of jurisdiction. The Nazi memorabilia case in Yahoo that you may remember. The Yahoo allowed the offering of Nazi memorabilia on its website. I think it's on eBay. But anyway, you could buy them through Yahoo. Yahoo was based in America, but it contravened French law. There was a big hullabaloo. In the end, they made arrangements whereby those offers were not made to French citizens, but they didn't challenge it either in the U.S. Constitutional Court or in Strasbourg, which again is a pity. It goes to show that you're talking here of an area where you really don't quite know what law applies where. So I just wanted to throw that at you for some further discussion. Have you, any other? Oh, they're applauding to me.
Okay, but here you have now, regarding what law applies. For law enforcement purpose, practically, if you investigate and you don't know where the data is,
right.
What law do you apply? To who do you go to ask for MLA and so on? What do you propose there?
Well, I would propose prosecutorial guidelines, such as you have in the UK and the Netherlands and Scotland, I know as well. And I was just asked a few weeks ago to go to the Director of Public Prosecutions, who specifically wanted to say what should be my prosecutorial policy on prosecuting hate speech and offensive remarks made on the internet. It wasn't transnational, but he said that he needed some guidance. He would issue guidance to prosecutors. And I would say some guidance to the effect that if the actor is abroad and the actions are abroad and they were not specifically directed at our country, then in principle leave it alone unless there are special reasons not to leave it alone. That's just a suggestion.
Yeah, I think Professor Sieber in Germany, he wrote a long report. I think it's in German only for the moment. Recently, where he also argued some of these cases, jurisdiction cases. I think it was a case where somebody did something in Australia, but it again violated laws in Germany, and I think they found the right way to approach certain things. But my question was a bit a different one. If you already have such a jurisdiction case where you have a suspect, where you have something that is considered a crime in another country, maybe a lesser crime or no crime at all in your country, it's a relatively clear situation as compared to an investigation taking place underway. You track data, you don't know where the data is physically. You have it, but you don't know where the data is. I mean, I could not tell you today where the different webmail accounts that I have, I couldn't even tell you which webmail accounts I have because I forgot, I have so many. But I couldn't even tell you where the data is that I have on webmail accounts. So even if I were voluntarily cooperating with you as a law enforcement, that would be something. I couldn't tell you where my data is. Now, if you have investigations going on, maybe even an urgent case, exigent circumstances and so on, you don't know where the data is. To whom do you address a request for mutual assistance?
Well, in the specific case that you're giving, Alexander, of webmail, you would need to go to the webmail provider and ask them where the data is being held if it's not within the jurisdiction. And if you followed the advice Dara and I gave in our Global Network Initiative report about using mutual legal assistance mechanisms where available, rather than just going to somebody within your jurisdiction who has control in cybercrime convention sense and requiring them to download the data transnationally for you, They can tell you where it will be. The webmail company will know where it is, and then you go to the country where it's held.
This is becoming a serious issue for many countries. And there are now a great many countries which we discovered when we did the GNI report, where the authorities say that certain data must be kept in their country, because otherwise they fear that foreign authorities will be able to have access to them. And a lot of companies are taking the same kind of measures. So this is an issue that affects companies, it affects states, it affects individuals, and it really needs sorting out, because it stops people from cooperating. It actually stops companies and states from cooperating. I heard just the other day, I think India is now planning a law saying that the communications data in India has to stay in India, because they don't want any law enforcement authority or any other people from elsewhere access to it. It's a big issue. It's not just a human rights issue. It's a commercial issue as well.
Okay, and then you have situations or rulings like the Yahoo case in Belgium, where Yahoo had no legal representation in Belgium, no legal presence in Belgium. The data was somewhere, but it had an effect. There was an urgent need for the data, the way I understood, in Belgium. They provided a service in Belgium, and the ruling was, since they provide a service here, they are here, we don't care where the data is, they have to give us the data.
At least they addressed the right party. They went to the service provider and presumably followed the rules in their law and said, under this law, you have to provide this data. Now, if Yahoo had come back and says, we will provide any data we have here in Belgium, but we will not provide you with any data we have in California, then you would have been back to the situation that Ian and I described anyway. You would have had to go to a court in California and ask for an order, and you would have had that very quickly as well. It's not as if it's impossible to get these orders, or at least so the Americans tell us.
So what are your views as law enforcement, or prosecutors, or ministry officials? One of the proposals made in this GNI, maybe you don't probably know what GNI means, right? Okay, maybe you can explain better than I, but it's the Global Network Initiative that was created about 4 years ago in response to situations where several US headquartered international service providers or internet industry players had to give data in China to Chinese law enforcement for Chinese to prosecute offenses which would not be a crime in the US, political dissidents in that case, to provide the subscriber data, I think it was, and so on. And was it Yahoo? Yahoo disclosed the data, and that led then to the conviction of individuals for political speech in China, and therefore they were asked to report to Congress and so on. So they decided to get together and develop some principles of how they would, what the conduct they would implement in such situations. So developed some principles. It was in 2007 actually that they started to discuss this. And it was the same time that we discussed the law enforcement ISP guidelines. And when you look at the GNI principles and the law enforcement ISP guidelines, you see some cross-fertilization there. So you have now a number of primarily US-based companies that are part of this global network initiative. And the two gentlemen here, Ian and Douwe, they prepared recently a report that you have a link somewhere in the notes that he sent around to all of you. It's called Digital Freedoms in International Law, and they make a number of proposals, including the proposal that private sector entities, a government should only go to private sector data through mutual legal assistance, unless it's in their own country, of course. But if it's the data in another country, through mutual legal assistance. What are you thinking about that? And then you also say for that mutual legal assistance has to be made much quicker, much faster. Yeah, but you still haven't provided more details on how that can go. But so what do you think about this proposal that to get data from international service providers, you always have to go through mutual legal assistance, which means that French law enforcement cannot go to Microsoft in France, but they have to go MLA, United States. Even if you have Hotmail FR users, you would still have to go to the US through MLA.
Yeah, unless they decided to set up a server for their French users in France. And maybe the French authorities could persuade them to do that. And maybe some people would then not choose this particular service provider. But that's if the data are in California, I think while the Americans would be very happy to grab any data that are here in France or here in Azerbaijan, I don't think they would be quite happy with a French or an Azerbaijani authority grabbing data that are held in the United States.
But again, what is the, if you talk about a French investigation with a French suspect, French IP data, clearly pointing out this data, okay, as clearly as it can be, of course, and with all the intricacies there. And Microsoft in this case having a representation in France, and Microsoft in this case, let's say, only providing access to traffic data, not content. Okay, we can argue also about concept of traffic data, but not content. Why would the US have anything to do with it if it's just by coincidence that the data is in Iceland or in New Jersey or in Ohio or somewhere? What would be the link?
Well, I mean, as Ian pointed out, and I did put that in the report, any textbook on international law, if you look up the topic of jurisdiction, it has a subtopic called enforcement jurisdiction, and it says states are limited in their jurisdiction, in their enforcement jurisdiction, to their own territory. They may not exercise enforcement jurisdiction on the territory of another country. It's like kidnapping somebody on the streets of Milan, which the Americans have done as well. It is the exercise of sovereignty in another sovereign country. And in terms of public international law, it is really quite questionable, is to put it mildly.
Unless it's regulated in an international treaty.
Yeah, unless.
Okay, so it's regulated here because both United States and France are parties to the Budapest Convention, Article 32b. Microsoft voluntarily agrees to cooperate. They're not violating US law because under US law there is no obstacle to providing traffic data, subscriber information. There would be an obstacle providing content data, but not traffic data. So what's the problem?
Well, the problem is that Article 32 isn't clear, as your own explanatory report says.
But also more fundamentally, that isn't what we're arguing against. That's what we say in the report. Where there are international agreements precisely of this form, that's fine. Well, not quite of this form, but specific and fulfill all the requirements of European law and so on. That's fine. What we are saying is problematic is if that kind of thing is happening in an entirely voluntary, in quotes, unregulated way, particularly requests coming from countries that are not members of the Council of Europe, that do not have the human rights standards of the Council of Europe countries.
Okay, so we can take it that between the parties to the convention, Ian and Uwe are in agreement with 32.
No. Because, and that's why I made this the longest quote in my paper, is from the explanatory report that actually says you haven't been able to resolve this yet. And I'm not blaming you for it because it's not easy, but it says it in so many ways.
You're misreading the report because they said they would have liked to do more, but the only thing that was agreed upon was the limited circumstances of 32b. Now the thing is 32b, of course, leaves some room for interpretation when it comes to the details, but that could be clarified.
I mean, there are other situations in which this kind of action is neither authorized nor precluded. That is no help to anybody. And another question is the question of who is a person who is lawfully authorized. And I think there is a deliberate ambiguity there. And if I take the American approach, they basically say anybody who holds data that have been disclosed to them is lawfully authorized to do it. This is the third-party doctrine in the United States again. Everybody holds data is lawfully authorized. If I look at SOFI, I would say SWIFT is not lawfully authorized to pass data on to the United States because there isn't adequate data protection. So that concept of lawfully authorized is problematic in this context as well. It hasn't been resolved, Alexander.
Okay,
I know.
the SWIFT thing would not have been covered because it's not a criminal law issue. It was a bit of another issue there. But again, okay, but I think that's what we also found, that 32B may need some explanations and so on, but in the end, I think, okay, let's not get into details now, because maybe in December, in a month, we have some solutions. Sorry, over there and then over here.
I would like to talk about Yahoo case in Belgium. I appreciate prosecutors in Belgium because, according to my belief, they are right. Yahoo, although it's a United States company, but it provides a service in Belgium, and Yahoo is a multi-billion, or I don't know how much its budget, but they do not record any person there, and they do not record themselves to provide data to prosecutors because of their national jurisdiction. But I think here is Yahoo or Google. I think United States should make a clear their position in internet. Internet is called World Wide Web, but Wide Web this is USA Web. So in the morning I said the big important issue is iCloud, and iCloud is increasing, and they couldn't raise an argument that their national legislation, United Nations legislation, doesn't allow them to provide such as things. So this is very important. Maybe Internet Governance Forum is a good place to important of the future of the World Wide Web, not USA Web. Thank you.
Certainly a good place for brainstorming, but the IGF is not allowed to make any decisions or make any recommendations even. But for brainstorming, very good. Branko?
Shortly to answer your question about the possibility to have the MLAs for getting the information for the private ISPs. I, as a prosecutor, I believe that that kind of the solution would only slow us down. That already we made the progress with the private ISPs to let's say adjust their policies in order to better cooperate with the government sector. So that's one of the parts of the cooperation between the government, public and private sector, right? So if we are going to just renounce that kind of the cooperation in this moment, we are going to effectively take one or even more steps back and go to the MLA waters, which are very slow and very complicated for so many countries in the world. So if we at this moment have a kind of the cooperation with the largest ISPs in the world, which can give us certain amount of the data justified under the EULAs of those respective companies, and are meant to be used only for the purpose of the criminal investigation, then we are all fine. ISPs are fine, and the public authorities, meaning the LEAs and the public prosecutions, are fine. On the other hand, because we are talking so much about the US, let's be completely frank about it. I believe that maybe even more than 90% of the data which has been provided to the legal enforcement agencies and the public prosecution came from US companies. I cannot recollect one single case in my country in which some other state provided me with some kind of the data which is very important for my investigation. Budapest Convention or no, or without the Budapest Convention. Okay, within the Budapest Convention, it's a bit easier. For example, I got some information from Romania, some from France, but still, you know, the majority, the bulk of the data I got in my investigation is from the US. And God forbid I ask something, for example, from China. I'm not even, you know, recognized as a country, you know, to receive any kind of information. So let's be frank and let's talk about, you know, the reality in the world. We have the criminals for which we are conducting the criminal investigations, and for those criminal investigations we are gathering informations from those who are willing to give us those informations within their line of the law or legal framework, if you like, and within our legal framework. So as far as that kind of the cooperation works, please do not, you know, take us 1, 5, 10, even 20 steps back and just, you know, push us into the mutual legal assistance. On the end of the day, for example, if the ISP is not willing to give us that kind of information for any kind of the reason they find suitable, we are going to be forced to enter the mutual legal assistance, you know. So it's going to wait for us on this curve or another curve. But on the first curve, if they're willing to cooperate, you know, within their legal framework and our legal framework, wow, fine for us, you know. We are going to catch the bad guys, you know, and do the justice. So that's it. Thank you.
Just one comment on the numbers of how often preservation powers are used. One argument that came up repeatedly from the parties of the convention is they don't use it much also in relation to international requests, because it would have to be followed by MLA. And they said it's a nightmare, it's complicated, difficult, we will not get anything out of it, therefore we don't even preserve or we don't really follow up to international preservation requests. So it's there is an issue there. And I think also this tolerant policy of the US to allow US companies to share data also with other law enforcement, it's not really a matter of reciprocity, because European-based providers are not giving any data to US in the same way that US companies give data to European law enforcement. But you,
I had a point. You know, it's absolutely normal. I've seen it in various forums that there's a lot of American bashing on various issues. From a person who comes from a developing country who uses the internet, if there was a country where my data was kept, I really would want it to be. I would want it to be the U.S. because of the protections of freedom of speech that it allows. You know, forget anybody else in the world. That is probably the best place for my data and for my service providers to be housed, so that I know that if supposing there's a TLD, it's not going to be taken down and blocked because of free speech issues. If I'm otherwise going to be prosecuted for blasphemy in a different part of the world, the U.S. court's not going to come in and say, well, we're going to shut it down. So first of all, let's be frank about one thing. So I think it's great to criticize the gold standard, that it should be diamond, but let's appreciate the fact that it is a gold standard and everybody else really is silver or bronze. Now let's take the UK, for instance, because you're from London. You know, we have never had an extradition from the UK. Every criminal from Pakistan visits the UK and is sometimes on your tax dollars sitting there. We've only ever had extradition from the US. And we have an MLA with them, but we don't have an MLA with the UK because the UK probably wouldn't agree to it. Maybe Pakistan wouldn't want it. I'm not sure. But the only time we've ever seen cooperation has been with the US, and that's with a country like us. Getting a corrupt case, get an extradition request, the FBI handed him over, brought him back on a flight. That's saying a lot. There are red notices out for President Musharraf. The UK won't move an inch. There's a guy who's a terrorist from the MQM who's actually been given asylum in London. There's no hope in hell to be able to get him to come across from the UK. So, you know, let's be fair as to the examples that are there. But there are other things I'd like to say. This situation with sharing of data and the fact that certain entities have it is not unique. It exists in other areas as well. Banking, for instance. UBS in Switzerland has had to hand over data. There's no treaty related to that. No, but there was voluntary consent. If what's happening right now is that the U.S. Department of Justice is having discussions with various banks in Switzerland, saying you want to hand it over voluntarily, fine. Otherwise, we'll prosecute you. So they're saying, wait, we don't want you to prosecute us. Wherever we might be, we'll hand it over. Let me repeat this word: voluntarily. Voluntarily. This is not unique, this is not strange, this is not science fiction and new, this is absolutely something that is happening and has happened several times in other places. It is not true either to say that US has a third-party system where basically you hand over the data and you're done. That's not true. It's a patchwork. There's something called HIPAA, so there's health data. You will be prosecuted anywhere in the world if you were from the US and you handed over that data. I know because I have outsourced it in Pakistan who have to handle HIPAA data from Pakistan, and if something goes wrong, they're going to have the FBI looking out for them. The same is true for banking as well. So it's generalizations can go so far, but let's be fair. There are certain areas where there may be concerns and we can discuss them. But I want to come back to your question. There are other actors who are members of the convention, some who aren't members of the convention, some of them who house a lot of data, a lot of routing traffic data as well as content data, where people who are doing fishing, farming, hacking, etc., are hoping that their data is stored in those countries on the other side of the world from the US so that nobody can get to them. Some of the examples were quoted earlier. So I appreciate the thing, but let's be on balance.
I'm sorry, but I missed most of the point of what you said. We weren't US bashing. We weren't talking about terrorists being extradited. We certainly weren't holding up the UK as a gold standard in any of these things. So I'm afraid most of what you said just.
So let me try and be a little more coherent. We were talking about Article 32B and the fact that it just isn't sufficient, and the fact that there was language inside Article 32B that says voluntary disclosure if you have legal authority. And there was some problem with that. I still don't understand what the problem with that is. Not every, and we were talking about this in the context of the U.S. specifically. I think that's what I got from the discussion. So if it's HIPAA data in the U.S., they wouldn't have lawful, authority to disclose that data, right? They couldn't voluntarily disclose that data. So that's an example of what they couldn't do, because it's not generalization. Or they can do that can happen with any kind of data. So that's one response.
And not banking and not video rental.
Right.
There are some other
areas. Others,
I mean,
but there are others.
There are some very tiny layers.
But there are others, and as I said, there's a distinction in which you accepted early in the morning of cultures.
No, I didn't accept that.
Not necessarily. But I'll tell you one thing, and a prosecutor spoke earlier, and I work with my law enforcement, and I mean, we actually represent businesses, etc., who do want to go after people who are doing intellectual property crime and a whole bunch of other things, bad things. And I can tell you the most important and the most useful thing that you can mention in the convention are two things. The United States of America is a party to the convention. That's the most important thing, the selling point of this convention, because the data is housed there, so you can request it. And number two, it allows you a legal mechanism by which voluntary disclosure of data from, say, Google, Facebook, etc., would be under Article 32B possible. Without those two things, this is a dead duck.
Well, I agree that Article 32 is absolutely crucial. Let me start with the first point that went over Ian's head, because it didn't go over my head. I've done a lot of training of judges and prosecutors in Uzbekistan. And the one thing I tell them there is, if you torture people, you're a criminal yourself. I said not only that, if you torture people, you prevent good international cooperation in fighting crime. So if the United Kingdom is unwilling to extradite people to Pakistan, then I think Pakistan should also look at a mirror. Why is that not happening? Presumably because judges in the UK say they're going to be either persecuted or tortured if they are handed over. Because otherwise I'm sure they would be. Sorry? Oh, yeah, but the US has not that many qualms about torturing. The US tortures. Oh, come on, that is the problem. That is the problem. No, it is the disdain of the United States for human rights in the recent times that it really makes crime cooperation problematic. That is the big obstacle. The big obstacle. I would like terrorists to be handed over to Pakistan if they got a fair trial and were humanely treated. But if that is not possible, don't blame the UK for not extraditing them. Blame yourself for having bad practices. I'm sorry to be strong on that one.
No, I think you're right. But let's President Musharraf is not a terrorist.
I'm not going to go into the Musharraf. No, and on the broader point, in the United States, you have some specific decent bits of data protection privacy law. But they are, as you say, very patchy, and the broad picture is, from a European perspective, I'm afraid bad, in particular because of the third-party doctrine. That any data that have been handed over to a telecoms provider, a car rental company, anything else, are basically free for being handed over to law enforcement agencies, quite contrary to the European principle of purpose limitation. That is, and yes, it's a cult. I agree with you that there's a big difference in culture, but I think we in Europe have the right culture and the Americans have the wrong culture. So I think that, so you can't just say, oh, well, they're just as good. No, unfortunately, they're not. And that is the problem we're up against here. I think if you say the Americans are happy with this, I'm not entirely sure how much this is above board and how much people know what data. Do the Americans hand over data on US citizens under these arrangements?
No, but that's why was saying earlier. The way I understand many of these arrangements is that if it relates, if you talk about France, French IP addresses, French suspects, and so on, it's really, there's a link to the territory. Right?
There's a link to the territory, and if
not just anybody.
But I mean, formalize it. If you say the United States authorities are happy for their companies, American registered companies, to cooperate with European and Pakistani other law enforcement agencies in these kinds of requests, then say fine, put it on paper in a good drafted form where you build in the right kind of safeguards. Then I can live with it.
I have a constructive statement here. I think there's a distinction that you made, and I'm glad you raised Pakistan. Pakistan, as I mentioned earlier, is actually a concern when you want to share data with countries like mine, because you've no idea. It's got nothing to do with the fact that they're going to use it for torture or anything else, but the fact that there will be for abusive requests. Maybe it's a corrupt law enforcement agent, right? And that is precisely why what you're suggesting that you should put it down in writing becomes a problem. And that level of discretion that is available with the law enforcement or with the Home Department or whoever it is, to say, well, we have to judge whether or not we actually decide to hand this thing over, person or data over, should be up to the discretion from a case-to-case basis. As an example, let's look at the two different cases that happened a few weeks ago in the UK. One was for a terrorist, and they were extradited to the US. And the government of the UK decided not to extradite the gentleman you mentioned who's autistic, for the reason that he was autistic and many other reasons. So if you were going to sort of reduce this in writing to such detail, beyond what we have in, say, a convention like this right now, you might find that it would then, it's a double-edged sword sometimes.
And let's also not forget that governments want other governments to go through mutual legal assistance. It's not only to protect the rights of individuals, but also for general political consideration and so on, which is very often the case. For example, the UK may have also decided to prosecute somebody if they don't want to extradite, which also apparently didn't happen. So there are all sorts of political, messy issues there. Can we say 2 words for 2 minutes about the issue of national security versus criminal justice? Because we have to finish in 5 minutes.
Oh, okay, well, I'll try and be very. The big issue is that the advent of terrorism, especially 9/11, has pushed the activities. Has blurred the lines of the activities between national security agencies and law enforcement agencies. I think everybody can see that. And that is problematic when you're talking about something that should be as tightly regulated as law enforcement activities traditionally are. It goes in the means of investigation. More and more police authorities are using the kind of techniques and technologies that used to be the reserve of the national security agencies. And it also goes in a way the other way around, that many of the data that are collected in all kind of ways, but also by law enforcement agencies, end up with national security agencies. And I am worried about especially the American ones and the way they feed this into their it used to be called the Total Information Awareness System, and Ian and I wrote something about that. They have abandoned the name, but they haven't abandoned the concept of basically trying to get as much data as they can from any source whatsoever. And my fear is that quite a lot of the data that in good faith is passed on and bandaged around from law enforcement agencies to other law enforcement agencies in the United States in particular ends up in this massive national security mess. That Ian can say a little bit more about. The systems there are massive. They are used in uncontrolled ways, in ways that I feel are seriously contrary to democratic values and the rule of law. And it taints the good law enforcement agencies that are used to operating within a clear framework. Let me just put it like that. Do you want to add anything like that? Okay, that's the basic problem.
It may unfortunately not just be limited to the US. I know it's your favorite country when it comes to your studies, but what you also have is in some European countries that you have national security agencies or state security agencies responsible also or co-responsible for cybercrime investigations, which creates lots of concerns and pains and so on. So we also have to look at it from that angle. With that, we need to close. I'll make conclusions are that the point was made earlier. We need clearer rules, better safeguards, better justification if we talk about measures that interfere in the rights of people, and clearer limitations regarding and conditions regarding human rights, rule of law, data protection standards. We need more time, and we need to figure out this national security versus criminal justice issue. One point is that was made in Brussels when the EU Parliament discussed the data protection package, that if you make it increasingly difficult for law enforcement to cooperate, you push them from the criminal justice into the national security arena because their limits don't apply or they apply to a lesser extent. So that risk is also there. One has to find a good balance there. And as a follow-up with regard to the Eastern Partnership countries, Drazen will, in the coming weeks, prepare a report on the Article 15 question. So he or via Gerko may come back to you if additional information is needed. And then we will also have a better idea on the Article 15 issue, Article 15 in the broad sense. Okay? Okay. And how that plays in Europe. Okay, with that, we had a difficult start this morning. We were facing difficult conditions. We made it. We had nothing to eat. And but still, I think it was hopefully useful for everybody. I think the attention is clearly there. We know what the issues are. Wish you a good time here and also good further continuation in the IGF. Make use of this mess of the brainstorming sessions that you get. It's highly useful. Thank you.